Hello, good morning, everybody. Welcome to Sunrise Daily. Today, I am Chamberlain Oso.
And good morning. I'm Nelta Ibi.
I'm from Lagos. Good morning and welcome. I am Bukola Koka.
September is 8 days old already. It's a Friday morning. Welcome to the program. I'm Ayo Makinde.
September 8 days old, our human calendar. Ayo, thank you so much for keeping us abreast of things. But Chamberlain, just before we move on to the papers real quick, the president made a statement yesterday, but there's something he said that I think every one of us in Nigeria and beyond Nigeria needs to take cognizance. The fact that, see how we all greeted, we said the same thing here, the four of us, but we all said it in different ways. There's strength in diversity, we've heard that before, but we need to acknowledge that at every point in time, every one of us has a strength that the other doesn't have. And when we all bring it together, we get stronger. I mean, in the football team, you have the different parts. You have the attackers, the midfield, the defense. When they work together, there's a possibility that they'll continue to win. But if, let's just say, the attack decides that he wants to play all alone from the goalkeeper all the way to the other goal, from one goal to the other, there's no guarantee that he would score. But when they work as a team, understanding that each person has a strength, some play from the left, some play from the right, some from the middle, but everybody comes together to ensure that we come out with a goal. Nigeria has a game, this weekend or thereabout, I think. So see how it works together. If that team decides that we are diverse, but we are together and we're going to win. That's how it works. If we would only understand that and harness it for the growth of our nation.
A lot lies on politicians, how they conduct themselves, what they do, putting their money where their mouth is, and ensure that they lead from the front, showing example with the appointments, the decisions they take, the steps they take. All of that has to reflect what they want us to do, because if anything short of that, you send, of course, a very wrong signal. But in the meantime, there are still more reactions about the presidential election petition court. And so that's why we'll dive right on to the dailies and take a look at Daily Times. And reactions from yesterday. We will not congratulate Tinubu. To Supreme Court we go, Atiku Obi declares. So that is a big lead on the front page of Daily Times this morning. And yes, you see several other dailies highlighting a similar narrative, which they all spoke about yesterday. But beneath that, this, surprisingly, to a lot of people, is still going on. Nigeria loses 30% crude oil to theft daily. That is ascribed to the speaker. Well, guys, remember the speaker had said that they were going to name names, all of those who had been involved in illegal bunkering, oil theft. They will name names. Well, we'll see, because we've been through this road before, where they told us they were going to name certain people, prosecute certain people, and we haven't. And as a matter of fact, the president talks about how fuel subsidy is a racket and certain persons responsible for it, how there is a lot of smuggling going through our borders. Here to have customs. We'll have, I think, DSS too, at once upon a time, deployed personnel to monitor those tankers. And we still don't have names. So who are these persons who have been involved in all of these illicit activities? Who are they? Are they being prosecuted? Who are they? Big questions. Well, there you go. That's our Daily Times this morning.
Taking off with the Vanguard newspaper, they have that reaction as well, Vanguard newspaper, and it says, Election Tribunal Judgment. Mixed reactions as Atiku Obi heard to Supreme Court. That's what Vanguard newspaper is leading with. That's what it continues on page 5. The writers here, are, I won't validate, mandate banditry. Atiku says, adds, we've lost the battle, there's war ahead. Words. No relenting in my quest for justice, Obi. Mixed reactions greet verdict. APC commends judiciary for strengthening Nigeria's democracy. We won't contribute to inciting people, northern elders. Court rulings should be respected. CNG. We'll make our position known soon. Afenifere. PEPC ruling a charade. MBF. I didn't anticipate this kind of negative ruling. Ezife. Ruling confirms Tinubu as Nigeria's choice. Oyebanji. Verdict has revalidated renewed hope. Akeredolu, ruling late justice prostrate. Stood technically triumphant. Wazirike, quest for new Nigeria being truncated. Imobi Igbo. Well, all of these are various reactions to that one judgment. But there's something here that's above the nameplate, and story continues on page 9. See the president talking. He says, Nigeria poor in leadership management. That's credited to the president, just above the nameplate. And then some security situation there in Abuja, 30 killed in Abuja landslide and 19 kidnapped on page 7 as well. But that's it from the Vanguard.
And up next is the Nigerian Tribune, which also follows up on reactions to the Presidential Election Petition Court ruling on the February presidential election. Atiku Obi, why we're going to Supreme Court. A host of writers here, just listen to them. Election court judgment lacks justice. I reject it as ex-vice president. Election petitions will be non-existent if INEC discharges its functions transparently. That's ascribed to the Labour Party candidate. Amend Electoral Act to ensure conclusion of litigation before swearing in. That's ascribed to the CUPP. APC pleads with Atiku Obi to join in nation building. That's Adegboruwa, Aliu, Clark, others, of course, weighing on the matter. And we'll also be following up on that with more reactions from legal practitioners on the program later on today. But there are quite a number of other stories that will definitely interest you on the front page of the Nigerian Tribune this morning. Under the big story, we have 19 kidnapped in FCT Council. Wike may hold emergency security meeting, 30 die in landslide. So there's a lot happening there. Security and development. Right under that one, $46 billion crude oil stolen in Nigeria in 11 years. As a follow-up on the continued hearing of the House of Representatives, of course, we want to hear names. We hope that that committee will walk the talk. And, you know, there were some interesting revelations from the hearing yesterday, where one of the speakers said the greatest beneficiary of Nigeria's stolen crude is Ghana. And then another, private sector person also talked about how they manufactured an equipment that could monitor the, stolen crude on the pipelines of Nigeria. But the NNPC, somehow refused to, actualize that contract, so to speak. So there are quite a number of revelations that should be followed up on. And the House of Reps also talked about how the NNPC didn't honor its invitation, with the hope that the NNPC will honor its invitation in the future. We hope that, these revelations would just not be swept under the carpet, and that they will be followed up conclusively. There's one more from the front page of the Nigerian Tribune. 10 arrested over killing of 200-level Fuoye students. That's Federal University, one of the universities in Ekiti State. Body found in shallow grave behind lecture hall. Very sad one there. Makes you wonder what kind of society that we're in. That's it for the Nigerian Tribune.
Oh dear. The Guardian newspaper is looking away from the main story in the nation as for its lead, even though the story is also right there on the front page. Atiku Obi reject PEPC ruling, head for Supreme Court. The major story, the main story, poor lessons from 2020. Endless wait for palliatives in states amid accountability deficits. This is something definitely worrying, given where we are coming from and how high expectations have been, especially in the light of current realities so many people are dealing with. Right at the bottom, well, in between the three stories, right above the major story, let the hammer fall on same-sex unions. I don't think that needs any telling. There's a law, right? So let the law take its course. Right under that story of the Supreme Court, Nigeria needs prayers to end insecurity, says Defense Minister. Yeah, prayer. Yeah.
Nigeria also needs work to end insecurity.
Thank you very much for helping me put it right. That's the Guardian newspaper this morning.
Okay, Leadership Friday is next. We'll fight on. Atiku Obi say after tribunal verdict, head to Supreme Court in search of justice. I lost the battle, won't lose the war ahead, ex-VP declares. Struggle for justice continues, says LP candidate. Lawyers differ on judgment. Of course, what would you expect on that one? So, always going to be what it is. Let's see what else is here. 14 officers, 9 soldiers face army court-martial in Abuja. You might want to pick up on that one. That's the Leadership Friday today.
Well, Daily Trust is what I have here. And again, that story. Atiku Obi reject judgment, head to Supreme Court. Legal battle to reclaim mandate just begins. Ex-VP reasoning conclusion unacceptable. Ex-Anambra governor, you will face another round of defeat, APC tells. Akpabio Kogi Gov asks duo to accept verdict. But here, organ harvest, police arrest doctor over woman's missing kidney. Sheikh Al-Gungu buried. South Africa reviews proposed hijab ban for nurses. But above that, it's this one that really sad. Landslide kills 13 FTT 19 kidnapped. Missing 4-year nursing students' corpse found. Phew. Leadership deficit held Nigeria back, says Tinubu. Yes, he said that to make a difference. And that's it from Daily Trust.
And up next is This Nigeria, which also follows up on the PEPC ruling. Next up, Supreme Court. Atiku Obi head for Apex Court, seek to upturn tribunal judgment. Don't waste your time, Kogi Governor Bello advises them. And right under that one, there's a follow-up on the president's visit to India. Nigeria's energy transition requires 810 billion naira investment annually. Despite all of the happenings at home, the reaction to the Supreme Court ruling, the president seems to be quite at home in India, making a case, presentations and pitches for Nigeria's economy, and this is just one of them. And right under that one, FAN relocates flight operations to Lagos Airport new terminal. That appears to be a follow-up on the minister's visit and announcements of major changes at the Lagos Airport. And also, quite a lot is happening at the State Assembly in Lagos. Again, Lagos Assembly rejects 2, confirms 15 Sanwo-Olu's commissioner nominees. And other papers, capture the Assembly as having confirmed the nomination of Commissioner for Health, who has been renominated, and that of Information, who has been renominated as well. And lastly, above the nameplate, right beside the nameplate rather, Nigeria has lost $100 billion that would be to Northeast conflict, says UNICEF. Let's leave it there for. Okay, just before that, the energy transition story actually says Nigeria requires $10 billion investment annually. And that's it for this Nigeria newspaper this morning.
Daily Independent has this one on its front page. Atiku Obi reject tribunal's ruling, head to Supreme Court. That's the lead story, of course. Quite a lot has been said. Sincerely, this judgment literally belongs to, the perspectives differ based on personal interests, I guess. But look at it. PEPC failed to restore confidence, ascribed to Atiku Abubakar. Peter Obi says no relenting on his quest for justice. And the tribunal judgment, a miscarriage of justice. So this one says, according to Huriwa, that's the lead story this morning. I'm going into retirement. Beg your pardon. I'm not going into retirement. Atiku replies Shetima find that story on page 6 of the paper today. But then, okay, say that story on leadership ascribed to the president. Leadership deficit pushed me to contest for president. That's ascribed to the president. So that story is right there, continues on the inside pages. Now you have a little more context in terms of that particular story. So, well, that's so many other stories on the front page that will take your interest, but that's the Daily Independent today.
Well, up next is the Nigerian News Direct this morning. Of course, we've followed up significantly with other papers on the big story. It's the same here. Atiku Obi reject judgment, head to Apex Court to justify claims. There are two riders here. Judgment bereft of substantial justice. Of course, it was also noteworthy to hear the former vice president and candidate of the PDP say, yesterday that he's known to put up a fight, regardless of what the ruling at the Supreme Court level would be. So to Supreme Court they go from here. And the second of the riders says, I shall not relent in quest for justice. That's the candidate of the Labour Party. So the fight continues. Let's go to the bottom strip to check on some other stories. Adeleke shuts down Osun Poly as suspended rector makes return. Just in case you're wondering what those details are about, you find them on page 3. And if you have applied for your international passport, here's good news for you. FG issues 2 weeks deadline to immigration to clear over 200,000 passport applications. It's a page 3 read. And you can also follow up on this on our sister program, Politics Today, from about 2 or 3 days ago, where our colleague had, that's our political editor now, Seun Okinbaloye, had a thorough and detailed interview with the Minister of the Interior. And lastly, despite challenges, Nigeria's telecom sector experiences upward shift, contributes 16% to gross domestic product. Let's leave it there for the Nigerian News Direct. And
with that, we have come to an end of a look at some of the major stories on the dailies, on the front pages of the dailies this morning. Our own agenda today on the program resumes when we return from this break. Do stay with us.
I take great pains to tell you that the decision of the Court of First Instance on this matter utterly fails far short of expectation. I am therefore here to tell you that though the judgment of the court yesterday is respected, it is a judgment that I refuse to accept. I refuse to accept the judgment because I believe that it is bereft of substantial justice. However, the disappointment in the verdict of the court can never destroy my confidence in the judiciary. Consequently, I have asked my lawyers to activate my constitutionally guaranteed rights of appeal to the higher court, which in the instance is the Supreme Court of Nigeria. Whether I prevail in this quest or not, the record of my effort in ensuring an order of credible elections in Nigeria shall remain for the future generations to emulate.
It is my intention as the presidential candidate and intention of Labour Party to challenge this judgment by way of appeal immediately as allowed by the Constitution of Federal Republic of Nigeria. The PEPC has rendered its judgment, but that esteemed body is not the final arbiter. The responsibility now falls on the Supreme Court. I do know that the judgment is not conterminous with justice. I implore Nigerians to remain focused, steadfast, and peaceful, and to abide by the rule of law and understand this matter has not reached its logical conclusion. Our legal team has already received our firm instruction to file an appeal against the decision. I shall not relent in quest for justice, not necessarily for myself, but for indeed for our teeming supporters all over Nigeria, whose mandate to us at the post was regrettably truncated by INEC. The strength and value of our democracy reside on solid national institutions and our confidence in them. Electoral litigations will almost be unnecessary and non-existent if the Independent National Electoral Commission discharges its statutory functions creditably, transparently, and with sustainable fairness.
All right, welcome back. So that is what we'll be talking about today. Reactions from that presidential election petition court's judgment, of which you heard the parties in question saying they are going upstairs. We've got some gentlemen joining us here in the studio to discuss this matter. Mr. Adamawa State is the former Attorney General and Commissioner for Justice for your state, also former Minister of Communications. And then sitting beside him, Professor Maxwell Gidado, a senior advocate of Nigeria. Gentlemen, good morning. Thank you for coming on today.
Thank you. Morning.
Yes, but we will have another guest, but when he joins in, we will introduce him. Mr. Shitu, you've heard responses from different parties. They're not happy with the judgment. Even some Nigerians, as expected, I mean, also finding some shocking questions. They just thought it seems that the way it is in this country, it will be very difficult to prove any case against any president who wins election in this country from the look of it. That's what some persons believe, having listened to that judgment. I know the APC, of course, will be happy about this judgment, and they think that this is going to go.
We worked for victory, and we got the victory, and those who didn't do their homework well expected that recruiting social media mobs to intimidate and overwhelm the court will make the court do the unjustifiable. And if you look at the judgment, every reasonable person, particularly lawyers, know that the court, in writing a judgment, must base its findings on evidence which have been supplied by those who go to court to seek for one judgment or the other. If you refuse to do your work and you expect, for instance, the judgment in several parts of it alluded to the fact that the people who came to appeal refused to bring evidence, substantial evidence, to the court. If you say that you have been shortchanged in an election, it is about figures. The court will expect you to come to court, bring results, physical results, from any of the 133,000 polling units, to say that in polling unit A, this is the result that was given at the time of election. This is what INEC posted for me. And the court will be able to compare. Merely criticizing INEC is like making INEC the whipping boy.
But what do you think about, because before that election, there was a lot of commentary from INEC themselves about BVAS, IREV, how they raise hopes of several persons that, look, you will see the results wherever you are, it will come through. Then came the presidential election, and people thought, we didn't see what you told us.
It is about figures. You are supposed to have your agents in every polling station.
No, I'm talking about the IREV.
The IREV, the court have said that the law on INEC, the law which guides INEC operations, did not make it mandatory for INEC to utilize BVAS or IREC or whatever The law, that's the finding of the court.
Sorry, if I will just...
Mr. Gidado seems to disagree with something.
Yeah, but before I come to you, Mr. Gidado.
Okay.
The court said it's not mandatory for INEC,
yes,
right?
Yes.
But the court also said it is up to INEC, going by the Constitution, to decide on how to...
And they decided.
And they decided.
Yes, yes.
And INEC, over and over and over, prior to the elections, kept saying the BVAS and the IREV is mandatory. That's part of their guidelines.
Yes, they did say that. For whatever reason, perhaps they discovered that they were not compared.
So is that not moving the goalposts in the middle of the game? It is
not about moving the goal. We are not guided. The court has said that the election is not guided by whatever regulations outside the law.
Okay, let's get to Mr. Gidado. Mr. Gidado, the law says INEC is at liberty to decide how it wants to conduct the election. And how to transmit its results. And INEC came out with a guideline that they're going to use.
Very well.
But the justices have said that, from what the teacher has said, the justices have said, it's not mandatory. So some argue that this is like INEC moving the goalpost in the middle of the game.
Very well. Now, I'm happy there's an agreement here that INEC was given the go-ahead to make guidelines based on the Electoral Act, the new Electoral Act. Because the new Electoral Act differs from the old, the 2011. The 2022 Electoral Act now says INEC, under Section 47(1), we've given you the leeway to make guidelines on how to conduct the elections. Now, and in doing so, in their Section 137(1) of their guidelines, INEC said the following procedures shall be followed as far as these elections are concerned. And the word shall connotes compulsion. In other words, you do it. And you were being guided. INEC wasn't just given an unfettered power. They had to be guided by what the law says. Hence, whatever they were to do has to be in line with what the law says. And they were the ones that came out and said, this is how we're going to conduct it, by the use of BVAS. And after the snapping of the Form EC8A, it's going to be transmitted real time. And Nigerians will have the privilege to compare what was snapped. Those that had the opportunity to see the Form EC8A would also view the portal and look at and compare. And if the results tally, if you are told you've lost the election, you have no option but just to accept.
Okay, because journalists in this country spoke several times with officials of INEC on this same BVAS and IREV. They were here, they demonstrated what to expect. In fact, let's just even refresh our memory. I know we heard it time and again where the chairman of INEC was speaking about what to expect to the international community on this. Just have a listen to this.
The second thing we are going to do, and pretty soon, is to conduct mock accreditation exercise nationwide ahead of the election. We won't wait until the main election comes. We'll test the integrity of these machines with real live voters in selected polling units across the country. We did so in Ekitan Osho. It was fantastic. We are going to do so nationwide. And increasingly, our people are becoming even more excited about the deployment of this technology. So we are really happy. And in terms of the numbers of the BVAS machines, we always make provision for additional numbers of machines in case of malfunction or glitches. And there is always a backup. We have what we call the RA technical support that will fix the machines in the unlikely event of any glitches. And where it needs to be fixed is fixed, but where it fails to function completely in a polling unit, and from previous experience there are isolated polling units, the law has a remedy that the commission should immobilize and conduct the election in the affected polling units within 24 hours.
thought that's as clear as daylight.
You see, we have said it earlier. There's a law in place. It compares certain things. It does not compel other things. If those who went to court haven't had their results from the 133 polling stations, if they could have come with those results, had copies of the results, to compare what eventually INEC released. If they did that, the fact that, because use of INEC or whatever, I mean, it is about mode of, transmission of results, not about the quality or standard or status of the result itself.
Doesn't that affect? Doesn't the way you transmit the result affect the mode, the quality of the result?
You have to come and tell the court how it affects it. It's not for the court.
Okay, but clearly, I mean, you've seen there and you agree that INEC, yes, they were going to do all of that.
They said they were going to do it. For whatever reason, they didn't do it, but the law does not provide a punishment for not doing what they said they were going to do, insofar as the law did not make it mandatory. What is mandatory is about the physical, writing of the report and collation.
Okay, so
and for anybody, if INEC came out to say that Mr. A won an election based on certain figures, okay, anybody to contradict that must bring a different set of results.
So you suggest that you're saying INEC took advantage of when the law says there's no punishment for them not doing what they were supposed to do.
It is up to them to do whatever they can justify within the ambit of the law. And I want to give them the presumption of good faith. They were talking of glitch, they were talking of some other things.
They said
this is about technology.
Prof, yes.
Yes, let me come in here. Elections are not Fendi. Elections are not Gucci. Elections are a very serious business. Now, a situation where you came out and told the whole world and the citizens of the country that this is how elections are going to be conducted. And you spelled out, you gave all the parameters of how the results will come out. Now, if, for instance, on the election day of the 25th of February, 2023, 3 elections were conducted: House of Reps, Senate, and Presidency. The House of Reps was transmitted successfully. No issues. So if you look around in the entire country, if there are contestations in courts, they are not contesting because they have issues about the way the results were transmitted. The law was followed there, no problems. Senate, ditto. But when it came to the presidency, they now claimed there were glitches. What sort of glitches are you talking about? Is that human error? And that's the question with the PDP and its presidential candidate challenged, because the law says there must be substantial compliance with the Constitution, with the Electoral Act, and the electoral guidelines before a result can be taken to be credible and legitimate.
Mm-hmm. But Prof, part of what he's saying, yes, which I think part of what the justices also ruled, is that even if that were the case, if the petitioners don't prove it, what do you want them to do? If it's not if they say that if that non-compliance, if you don't show us how that affected your results, what do you want them to do?
Oh, as far as the PDP is concerned, we did adduce evidence in some areas where we felt the results were changed. And they were all proffered. The states, the 8 core states were all stated. And even the evidence, the boxes were brought, and it was all presented before the courts, as far as that aspect is concerned. But we have over 7 grounds, or we had over 7 grounds as far as this the challenge of this presidential election results are concerned. So, but that is just a part of it. That aspect of the non-compliance with the provisions of the Electoral Act and the electoral guidelines as stipulated by INEC itself. So that's one of the first grounds that we thought the Court of Appeal, the tribunal, will be able to give that guideline, that judgment that will assist future generations.
You know, Prof, the question Chamberlain asked, and I want to stay with that a bit, where the court says the parties, the petitioners were not able to prove beyond reasonable that certain things were not done properly. For instance, one of the grounds was that the PDP alleged that there was violence and snatching of ballot boxes, and justices said, did not prove beyond
nobody came out.
So there was no evidence to prove beyond reasonable doubt that these things actually be alleged. At that point in time, are you saying that the justices were not able to see, you said adduced evidence in some place, and you had enough boxes for all of that. But that obviously wasn't
with due respect to my
witnesses were also invited.
No witness from any polling station was invited.
No, you weren't there.
You see,
so don't just
to assist you, perhaps.
I'm a counsel.
Yeah, I give you I congratulate you for being a counsel in such a high-profile case.
Thank you.
The thing is, number one, INEC is not the lawmaker. INEC does not have any role of making law. That is one. Number two, we have an election where there were 3 frontline candidates. One scored 8-something million, another one scored 6 point something, another one scored 6.1. These are figures. The man who was declared on the basis of the fact that he scored the highest number of votes of the 3. If anybody is going to court to disprove it, you have to be able to bring more votes, more figures, higher figure than the man who scored 8 point whatever number of votes. Merely making claims, with due respect, my learned, senior advocate, is not enough. My lord, my learned, you know very well, we are all lawyers. And we know that it is often stated that he who asserts must prove. Atiku is saying he ought to have been declared. Labour Party man said he ought to have been declared. Even between the two of them, they must give figures to show who among them has a higher vote to compete with Tinubu.
Mr. Shitu, let's allow Prof to talk to us about this evidence matter. The justices have given their ruling, and of course, you and your clients have said you're going upstairs. But that matter of, I want to read it here. Justice Samani held that the PDP's allegation of violence, ballot box snatching, did not provide videos or evidence that the allegations were criminal and ought to have been proved beyond reasonable doubt. So you say that the evidence was there. Are you implying that it wasn't looked through?
That is our point. Because, as I said, witnesses were invited. People that were polling agents, people that were supervisors at polling units, and they came with graphic evidence of all the electoral malpractices, and we laid it bare before the courts. They were cross-examined. The witness, the exhibits they tendered were accepted in court. But upon all this was what the judges came up with, and that's the reason why we have resolved, or our principal has resolved, we go upstairs. The beauty of it all is that that's not the final court. So we ought to get to the Supreme Court and get the pronouncement of the Supreme Court vis-a-vis the evidence, the avalanche of evidence that they were provided to prove. There were instances, for instance, where we brought the EC from EC 8As, where the figures were doctored. You would see the APC result increased, PDP results reduced, for instance. A Labour Party result also mutilated. So all these boxes that were brought were filled with this evidence, pieces of evidence, indicating that results were tinkered. And we now said, if And some of them were also related with the results from the RF. They differed. What was on EC8 differed substantially with what was found on the RF. We itemized all this and then calculated. And mark you, there was even an admission by the INEC and the APC that PDP won in 21 states. It's stated there. It's there in one of the reports and the piece of evidence that was tendered before the tribunal. So we have all this evidence, it's proved. And that's the more reason why we are relying on the fact that on appeal, all this will now come up and we will get to hear from the Supreme Court.
Mr. Shitu, let me read this statement from a lawyer about his perception about, you talked about some witnesses providing all of this. You want to respond before I go ahead?
Well, before you go, I am happy that we had 5 justices of the Court of Appeal. And all the 5 from all parts of this country agreed that the case of the petitioners lacked merit because they couldn't prove all essential ingredients to the satisfaction of the court and of the law. So, and Prof is saying something different. It is either the justices, the 5 justices, with due respect to them, are telling lies, or Prof and his team are telling lies.
Now, this statement says, first, on the holding that the witness statement of an unwilling subpoenaed witness must be front-loaded and filed along with the petition. The Court of Appeal was merely enacting a factual impossibility, which has invariably resulted in a miscarriage of justice, with the resultant striking out of critical, oral, and documentary evidence of petitioners' witnesses. The petition must be filed within 21 days of the declaration of the result of the election. Within those 21 days, the panel which will issue and sign the subpoenas wouldn't even have been inaugurated. How then do you compel the INEC chairman or REC to donate to you a witness statement on oath against his wish without a subpoena ordering them to do so? And he cites the applicable legal maxim, which just says that the law does not punish a person for not doing what he lacks powers to do.
Well, they can come up, and I know they are coming up with all kinds of arguments. I'm happy that they are going to the Supreme Court. I'm also happy that under the law, they cannot provide at the Supreme Court any evidence that they refuse or neglected to provide at the lower court. Because at this level, at this stage, I am from APC. Obviously, my prof is from PDP. So, and we have a judgment which favors us, which does not favor them. Being dissatisfied, they want to go to the Supreme Court. In support of the judgment of the 5 justices of the Court of Appeal, we would go and meet them at the Supreme Court.
We've since been joined by Professor Paul Ananaba, Senior Advocate of Nigeria. He part of the team for Labour Party. Good morning, and thank you for joining us on the program today. Well, part of what was read yesterday on the day is that the justice of the court did say that Labour Party, the petitioner, couldn't prove that there was manipulation across the country, because he also cited that, look, if there was any such manipulation, he favored the Labour Party candidate, and so among several other things, including the petitions that were struck out. And so in a unanimous judgment at that, so many wondered how this was the case, how the petitioners in that consolidated petitions couldn't prove their case.
All right, thank you. That's the opinion of the Court of Appeal, and we respect their opinion. That's their assessment. They have done their constitutional duty. We do not agree with their resolution of those issues, and that's why you would have known that our principal is willing to challenge those findings at the Supreme Court. I am not the Supreme Court. and I'm not going to sit on appeal over the decision of 5 justices of the Court of Appeal. We appeared before them, we presented our case. There's a wisdom in the laws of this country, the Constitution, saying if you do not agree, you should challenge such findings at the Court of Appeal, at the Supreme Court. And that's what we are busy looking at and doing now.
Yeah, go ahead.
Yes.
I was going to ask that some even thought that, I mean, push comes to shove, you will have at least a dissenting judgment. But in this particular case, that wasn't the case. In fact, one of the justices even cited the quote-unquote, the social media perspective on this matter, that were they trying to ambush the judges or put pressure on them to compel them to go in a particular direction?
Again, bringing in the social media angle and all that, those are part of the things we are going to canvass at the Supreme Court. But the point I've been made is that nobody says how a panel will go. Before that panel, it took over a month for that judgment to come. And you are not privy to the conferences of the justices and their individual arguments and how they were able to come up with the judgment again. So those are of the same issues. What we are concerned with now is what they have come out with. So there's something wrong with analysis of the social media or the other media or other individuals.
All right, well, Professor Gahadu, let me ask you, because help us shed light on this, because we've heard people say that there were loopholes and there were technicalities and the likes, and then some other persons thought, but there are senior lawyers on both sides, on all sides, as a matter of fact. They are aware of the loopholes, they are aware of the technicalities, so they can't cite that as an excuse. They should have done their homework to at least prove their case beyond reasonable doubt, as they say.
Yes, Chamberlain, let me come back to some of the aspects of these technicalities. For instance, refers to this issue of subpoenaed witnesses. Now, a subpoenaed witness is a witness that cannot be invited willingly, to come and testify. You have to subpoena him. The court has to order him, to come. And an example is the chairman of INEC. So for us to have him come to court, it has to be by means of a subpoena. And to get his statement on oath and file it all within 21 days, it's not possible. So the court allows you to bring him in at that time via that court order, and he comes and then testifies before the court. So we were miffed when we had the ruling or the verdict of the Court of Appeal. And it's one of those aspects that we are also appealing against when we get to the Supreme Court. Because as it is now, we are just relying on what we had in the court. This CTC of the judgment has not been given to us in the chambers, but we are expecting it this morning. We would go through it elaborately. Then these aspects of technicality that you also mentioned. Now, a good example that you can cite is on this aspect of the 25%, in the FCT.
Yeah.
Yes. This is a constitutional provision. The Constitution spelled it out that for a candidate to be qualified to be declared as a president of the Federal Republic of Nigeria, you must satisfy these 3 conditions. 1, in the event that there are 2 or more candidates, you must have secured the majority of the votes cast. 1. 2, you must have gotten not less than 1/4 of the votes, that's 25% of the votes cast in not less than 2/3 of the states of the Federation. 2/3 of 36 is 24. And it concluded with saying, and the FCT. Now, when you talk of and the Federal Capital Territory, there are so many Supreme Court decisions on the meaning of that word "and," which is conjunctive. And when read conjunctively, it means the candidate has to secure 25% of FCT. And there are also Supreme Court decisions before that. The case of Buhari against Obasanjo, 2003, and Buhari against Yaradua, 2008. What the Supreme Court said was that you don't need to win, but you ought to get 25% of the votes cast in the FCT for you to be a president of the Federal Republic of Nigeria. And the logic behind it is simple. The framers of the Constitution, I guess, don't want a president to come in where you will be the person to administer the FCT through your ministers, for you to be a tenant. At least let that be like just as a state governor. What the Constitution says, for you to be a state governor, you need 2/3 of the local governments, 2/3 of the votes of 2/3 of the local government councils within your state. So it's the same logic. As the administrator of the Federal Capital Territory, you need at least 25% votes of the people residing in the FCT. Mark you, FCT, people maybe look at the Federal Capital Territory being like as small as it was when it was first established in 1991. As it is today, the FCT is bigger than Bayelsa State. So that is the logic. And when lawyers, adduced evidence to prove that this is what the Constitution says, and the tribunal comes up with a saying that you don't need, to get 25%. Where we will not. That's their view.
Colleagues in Lagos.
We'll wait when it gets to the Supreme Court.
The disagreement between and amongst members of the bar and bench on the conjunctive and disjunctive nature of that portion of the Constitution doesn't help matters because we don't know if it has been decided conclusively following this tribunal judgment, or if it will still be represented at the Supreme Court level, and whether there will be an alternative view to that, or the Supreme Court would affirm the position of the appeal court, the Presidential Election Petition Tribunal, on that one. But let's follow up on the conversation, particularly on other areas of the rulings of the PEPT. Let me come to you, Professor Ananaba. The tribunal also touched on the issue of non-gender of the PDP candidate who came second, and wondered how Obi and LP's petition could be effectively determined without joining the candidate who placed second in the polls. Professor Ananaba, do you think this would have, how did your team miss out on this in the first place? And do you think this would have significantly impacted on the outcome of the judgment in your favor? Maybe not on all of the petitions that you presented, but at least on this front.
Thank you. I am a counsel in that team, so I have to choose my words and my perspectives. I'm not going to go all the way with beginning to argue the appeal that we are heading to the Supreme Court to do at this platform. But the point to be made is the Electoral Act specifies who a respondent in a petition will be. And the Electoral Act also says those who are not necessary parties in an election petition. Time there was when you will find that respondents in an election petition will be 200, 300, 400, 500 persons. But the Electoral Act has stated that you are limited to the persons who were declared. It's not a free fall. It's a sui generis proceeding. So it is one of the issues that we will take up to the Supreme Court. How will you defeat a petition, for example? Is it proper? Is it correct to defeat a petition on grounds of non-joinder when the person who was declared is made a respondent? It's just like when INEC is a respondent, every other person who did whatever it is, who is deemed an agent of INEC, and you don't need to begin to bring the polling agents, the SPOs, NCOs, and all that. So we didn't miss out anything in our petition in that regard. It was the contention of the second and third respondents in that petition. It was a contention, that we should have joined PDP and Atiku Abubakar. We don't think that is correct. We believe that our petition was competent and well constituted, and we've noted the opinion of the decision of the Court of Appeal. We will test that at the Supreme Court.
Professor Ananaba, if you say you'll test that at the Supreme Court, don't you think the Supreme Court will rule that it's an issue that ought to have been presented at the court of first instance and it was not, and hence it cannot rule on it?
No, you challenge decisions. You challenge the findings and holdings. So that's a finding. The Supreme Court will have to look at it whether our petition was well considered in terms of the parties. And precedents are being set, and these precedents are important. It's just that the CTCs of the judgment of the Court of Appeal is not out. It's just that it's not out. There are decisions of the Supreme Court, of the courts, that you are limited to the provisions of the Electoral Act. The Electoral Act never said you should join other persons beyond the statutory. I believe I heard the Court of Appeal say that the statutory parties are there in the Electoral Act. They are the persons whose declaration we are challenging. And we went the whole hog of even joining the vice presidential candidate there, who is the vice president now. We went that far.
So we have lost connection through to Professor Ananaba, but we're expectant on how the Supreme Court will rule on that one, following the decision of both candidates of the PDP and the Labour Party to head to the Supreme Court. But Professor Shitu, let me come to you now. It appears as if the argument on the burden of proof and the need to argue beyond reasonable doubt is unending. And Mr. Gidado has touched extensively on, what was presented by their candidate and their team at the Presidential Election Petition Tribunal. And I recall also one of the justices also touching on some television stations who acted as witnesses during the trial. And we can even also recall so many television materials during the live coverage of the election that showed, beavers machines destroyed, ballot boxes, thrown away, carted away in some instances. Don't you think with the presentation of that, it proves, it creates room for reasonable probability of doubt on the outcome of the election, even if not beyond reasonable doubt, and hence the tribunal court ought to have considered it?
I have no reason to think that the tribunal did not consider it. As of today, the law is the judgment of the tribunal. Whatever they have said is true until the Supreme Court reverses it. So I think that is enough for now. I just, before I leave, with due respect to my dear Prof here, he mentioned about the 25% of Abuja. The implication, because we must be very careful not to mislead the public listening to us. The implication of the argument of my dear Prof here is that if you have 24% in 36 states, 25% in 36 states, and you have majority of votes, once you did not have 25% in Abuja, all the 25% of your 36 states go to no issue. With due respect, it simply does not add up. It simply does not add up. The people in Abuja are not superior to other people elsewhere. So I believe in the next 2 months or thereabout, the Supreme Court would affirm every statement or finding of the appeal court.
Well, Professor Gidado, I'd like you to respond to that, because those are the exact words of the justices of the PEPC, saying that, look, as far as we are concerned, the voters in a particular location are not in any way superior to the voters in other parts of the country. How do you respond?
Yes, my response to this issue raised is that we are not saying residents of FCT are superior to all the rest parts of the country. Rather, what we're saying is that they are to be seen as equal to anybody in the country, but it is a constitutional provision. So if there's a problem with that, then we just have to find a way of amending the Constitution to remove that phrase and the FCT, which was the situation under the 1979 Constitution. 1979 Constitution never had they never included that a candidate has to secure 25% in the FCT. It just ended with 2/3 of the states of the Federation, period. But so long as the framers of the Constitution included that phrase and the FCT, the conclusion is that you have to secure 25% in the FCT for you to become the president, for you to be declared. Because if you look at it, President Tinubu is the only president that has not gotten 25% of votes cast in the FCT since the inception or the creation of the FCT in 1991. Beginning from MK Abiola.
Just a second on that one, very quickly, before we take a short break. If you can hear me, Prof. Just 1 second. If you can hear me, Prof. So what then does the marry this? Because the justices said during that ruling that the FCT should have been treated like it's the 37th state. And I also recall, I think it's section 299 or so of the Constitution that says that the FCT should be treated as if it were a state. So if you can just do that in 30 seconds, marry those two particular, facts with what you're saying right now.
Yes, when the Constitution said in section 299 that the FCT is to be treated as if it were a state, it was talking in terms of administration of the FCT. As far as the judicial, executive, and legislative powers of the FCT is concerned, when it comes to administration, it should be treated as if it were a state. When you say something is as if it's another, it means it is not. So the FCT is not a state. It is a special area carved out. It's also different from Lagos. When we had Lagos as a capital, Lagos was both a state and a capital of the Federation. But by the time we now move...
Just 1 second, because we need to take a break now to take a few messages. But just to want this final thing on that Constitution, section 299 says, the provisions of this Constitution, it didn't speak about administration there, but hey, I'm not a lawyer. Maybe that's just one of the perspectives. But there's more on this conversation when we return from this break. Just stay with us. Thank you for staying with us. Professor Nanaba, let me come to you. One of the presidential election court justices, Justice Moses Ugo, said concerning the petitions, and I quote, "At any rate, why did any of the two sets of petitioners not tender even a single polling unit result issued by INEC to their polling unit agents to support their claim of manipulation of election results by INEC, even as they all agreed that they have agents in the polling units?" That's one of the grounds that, it seems that's one of the grounds upon which the justices based their decision.
Well, again, those are part of the issues we are going to challenge. You were aware that we informed the PEPC that we had applied and obtained ex parte orders of the tribunal to get certified true copies of the results, and we didn't have that. It was back and forth with INEC at the tribunal. We eventually got some results. Now, in terms of the jurisprudence as of today, and like I said, I didn't want to start some of these analysis in terms of making so much comments when the certified true copies of that judgment is not with us. By Section 137 of the Electoral Act 2022, which is a legislation that is expected that the PEPC would have deepened. It says it will not be necessary to have oral evidence as we used to have polling unit by polling unit proof. The case of Arebo Shola and all that leads Ocha case and all that are there. There's a reason behind the purposive interpretation on Section 137. Now let me ask, if we were to call polling unit agents, over 176,000 polling units in Nigeria, let's even say we want to call for half of that, 80,000 polling units. How many years will it take us to prove the presidential election? So I'm not going into details, but I'm giving you an idea that the legal team at Labour Party knew what they were up against and met it. We tendered results. We showed issues of no results, absence of results, and all that. Fair and good, the Court of Appeal had taken a position. This will be going to the Supreme Court. Like I said, in a contest, the court will not speak from two sides. So the court has taken one side, and we're looking at it. We are going to present arguments for a review at the Supreme Court and believe that the Supreme Court will be more dispassionate, be more detailed, be more careful in analyzing that. And let me make this point here. These petitions are not about President Tinubu and Alhaji Atiku Abubakar and Mr. Peter Obi. If we focus on that, we will miss the point. These petitions are about precedent. They are about Nigeria today and in the future. In the course of discussions, I was hearing Buhari and Obasanjo, Buhari and Atiku, Buhari and these were presidents that were said before. And under the Electoral Act 2022, these are precedents we are beginning to lay. So let's not look at it because we are looking at the president Tinubu, or we are looking at Mr. Obi or Alhaji Atiku. Let the courts come to precedents that will be enduring, that will instill confidence in Nigerians to come out and vote, that will instill confidence in Nigerians to know that if anything goes wrong in the electoral process, the courts are reliable, the courts can be resorted to, rather than resorting to non-judicial remedies.
Okay.
That is what is at stake.
Yeah. Well,
and that's why we're going to the Supreme Court.
All right. Let me ask Professor Gidado the same question, because the Justice, His Lordship further said, had thought that this is the best and most effective way of proving the manipulation of election results alleged by them. After all, the polling unit is the only place where voting takes place, and so also constitutes the building blocks of election results.
Yes, as far as PDP is concerned, we did produce witnesses. We invited about 27 witnesses, and some of them were polling agents. They came, they testified that they were at the unit, they voted, and they also saw the way people came, used the beavers machine, and thereafter the transmission took place, and where they now testified the difficulty, for instance, in the transmission. So if you adduce such pieces of evidence, we were taken aback, when we had the tribunal come up with the fact that we never produced evidence, or people never came from the polling units, agents to come and testify. We did that very well. And as was also alluded by my brother Silk, it is very difficult within this short period. Even the 180 days, as far as we're concerned, or I feel it's even too unwieldy, it's too lengthy. I'm one of those that advocate that the duration be reduced in such a way that Nigerians will see a president being sworn in without any legal issues pending. So this wasn't the case up initio, but with the reduction to 180 days, within this period, if we were able to produce such witnesses and they came with the evidence, tendered it before the court, I'm surprised, to hear the tribunal turn up with such an assertion. But perhaps it relates to other parties, but definitely not the PDP. And the records are there to show. And it's one of those reasons, too, that when we go upstairs, we'll be able to adduce all these pieces of evidence.
Okay. Well, let me ask you, Mr. Shitu, there was something you said the other time, or I think maybe it was Professor, I was talking about the Constitution, the law, and the guidelines. We know that the Constitution is justiciable. We know that electoral law is justiciable. But the guidelines of INEC, which it produced itself and made a promise that IREF was going to be a game changer in the 2023 elections. But as we all know how that went, and the premise upon which a good number of people are, asking a lot of questions. So the question is, are you saying, maybe in law, whichever way, that the guidelines of INEC or the pronouncements of INEC and repeated confirmation or assertion of its position on IREF, are you saying it's not justiciable?
Well, your guess is as good as mine. But I just want to remind everyone that what is important in election cases with regard to the law is where not doing a particular expected act has substantially affected the outcome of the election. I have said it earlier. we have three, frontline candidates. One scored 8-point-something million, two others scored 6 million plus. Anybody coming to offset the one who scored 8 million has the duty on him, not on the court and not on the respondent, to show clearly, convincingly that not using that IREC has changed the results from what was the actual voting pattern. But none of the petitioners came to do that. My learned brother here was talking of, they have about 28 witnesses who came. Not all the 28 were even polling agents. That is to start with. Now, if you even imagine that the 28 are polling agents, in a polling station, perhaps you have an average of 100 voters. So 100 times 200 times 27 or 28 is about 2,000. How would that affect the more than almost 2 million vote difference between the winner and the next, and the next person? How does it affect it negatively to their advantage? So it is their duty, and it is not, with due respect, going to election tribunal is not about sentiment. It's not about emotions. It is as if you are, proving a criminal act where you must prove beyond reasonable doubt. People who voted for a winner will not allow any system which will bring about their votes not counting. If somebody wins, has majority votes, and then you come to say because if the petitioners felt there was not enough time for them to prove another, well, you neglect to do the needful at your risk. So as far as the election, the judgment is concerned, I am very confident that insofar as the petitioners who are going to appeal will not have an opportunity to do what they refuse to do at the trial, it is to their risk. But Mr. Shitu, if I may, I don't expect any different judgment from the Supreme Court.
Mr. Shitu, if I may come in there,
that the tribunal has done in analyzing the trial.
If I may come in there, Mr. Shitu, in what percentage of the states of the Federation would you require those concerns to be established for it to significantly impact on the outcome of the election? And apart from that, shouldn't the burden of proof now, in this peculiar case, shift from just the alleging petitioners also to the umpire, the one who conducted the election, to establish what it claims to have been the authentic situation?
I believe they have done that. They came with the result in their possession. The people doubting those results did not bring anything contrary to dispute or contradict the result that INEC submitted. What else do you want INEC to do? It is not INEC which went to appeal in court. It is individual respondents, petitioner. If they have petitioned, it means they have facts which are solid enough to persuade the tribunal to think otherwise or to contradict the votes, the 8 million votes. It is as simple as that. We have figures there. It's not about sentiment. It's not about I was overwhelmed or something. No. You are the one coming to say that the 8 million votes of President Tinubu are not valid votes. They are not genuine. Bring the genuine votes.
All right, gentlemen, we need to wind down now. Dr. Adamawa, let me ask you before we go, why do you think that your, okay, I think we lost him, Professor Porter Adamawa, but Professor Gidado, let me ask you, why do you think your principal will have a chance to overturn this at the Supreme Court?
Yes, as far as litigations are concerned, the Supreme Court is the apex court. It is the final court, and it is that court that we have the hope, and our principal has the hope, that with that expansion of about 7 of them sitting and looking at these aspects, one after the other, the issue of the FCT, the aspect of disqualification, which the tribunal I was surprised, said there were pre-election matters. Let the Supreme Court decide. It will be the Supreme Court, because they are we cited several Supreme Court authorities that said some aspects of disqualification are pre-election, but there are some that are both pre-election and post-election. So this will now go before the Supreme Court, and we are very sure that the Supreme Court will look at it dispassionately, and looking at the avalanche of authorities that were given by them, to the fact that some of these cases are both pre-election and post-election, then they will now give a verdict. So it is for this that the law has to be tested. That is where, as he also said one time when he was interviewed, if you lose at the Supreme Court, where else will you go? He said he will now take the appeal to God. So he is very confident, and we also believe as his lawyers that haven't looked at the pieces of exhibits, evidence, and the authorities we've cited. When we get to the Supreme Court, we believe the Supreme Court will look at this dispassionately and reverse some of the...
What is your impression about the social media perspective when one of the justices also spoke about that? Are they trying to put pressure on the justices?
No, you see, Chamberlain, the problem with this social media thing is that if you look at previous elections where there was no social media, the justices would just, after the cases, the addresses are adopted, matters are now left for judgment. You will just be relying on the television, the radio, newspapers, but nowadays, there is nothing you would do that the social media will not take one way or the other. And there are some of these people handling this social media angle that when you look at their level of education and the way they analyze things, you will know they have the handset with them. Someone in as far away as Oka, and someone as far away as Madagali, in Adamawa and Borno State. What control do you have over him? He doesn't know the justices, he doesn't know the rules of the court, and he will just come up with some conclusion. If this judge doesn't give judgment to my own principal, we are going to do this, or we suspect they've done this. So you see, the justices should just shut their eyes and their ears, to some of these social media the postings. That shouldn't serve as a threat, to them, or shouldn't gag them in doing justice to the cases that are before them.
Was that on court record, though, that it was putting the judges under pressure?
No, some of them, they were surprised that the judges read some of this stuff. Because as far as I'm concerned, if I'm not on a platform and I don't get news, where I know it's authentic. But when you get to hearing some of these gutter social media stories coming and saying, like someone saying he took it to the church and a pastor was praying on each of the candidates, for goodness sake, that stuff as a judge.
But I thought that, you all say that what happens in the courts of public opinion doesn't affect the cases before the tribunal, the courts.
I understand, but you see, that aspect of the judges feeling as if the entire social media it's like the society generally threatening them and telling them, you must do this, you mustn't do that, and etc., etc. So that was why some of them took it as if, that is, what is that disturbing them, that's worrying them, and it reflected in the judgments that they delivered. So as far as I'm concerned, they took it too far. You shouldn't have, gotten to that extent.
Well, Mr. Shitu, another senior lawyer also writing about some of this matter says that the principle of presumption of regularity of elections and that of the substantial conformity make it extremely difficult to prosecute elections successfully in this country.
Well, people have won election petitions all over the country, every now and then. In fact, only last week.
But not at this level. Not at this level.
At senatorial level, at governorship level, and so on. So it does not mean that it is not impossible. But the truth is, people assume that, based on sentiments, based on emotions, the judges should act in a particular way. No judge worth his salt will just write a judgment without having enough evidence to back up his assertions. He'll be putting his job on the line. Because even judges have, people who superintend over them at the higher level, at the Supreme Court level. So, it's not as if, but in truth, I want to believe that it is the same people propping up attacks on social media that were also responsible for billboards on, all eyes on the judiciary. It's the same people.
There's no proof there, is there?
Well, there's a presumption because, they were working...
But not substantial proof.
Well, so if there was no substantial proof, the fact of its existing in our daily lives in this country makes it of great concern.
But how does that put pressure on judiciary?
Of course, they have said it. Of course, they have said it in their judgment that
No, but they did refer to that. Wasn't social media. That was above the line. Outdoor advertising.
I am just saying that the issue of social media, the judges, said they would never be intimidated by. It is good for the purpose of us knowing as a country that when you have a case in court, it is better you look for a credible evidence rather than rely on sentiments, emotions, and campaigns of calumny.
But doesn't that suggest that, look, they don't, justice, whether it's seen to have been done or not, might be immaterial? Some may interpret it that way.
Well, anybody who wants to make, something out of it, since they are going to court of appeal, let's see. Since they are going to Supreme Court, let's see what comes out of that.
All right, Mr. Adamawa State, former Attorney General and Commissioner for Justice for your state and former Minister of Communications. And then Professor Maxwell Gidado, Senior Advocate of Nigeria. We also had the pleasure of hosting Professor Paul Ananaba, also a Senior Advocate of Nigeria. Gentlemen, thank you all for your perspective today.
You're welcome.
All right, so we will be back in a moment. We'll talk about some scenario in Adamawa. Don't go away. Edgar Amos joins us next. He's the Chief of Staff to the Governor of Adamawa State. Good morning, and thank you for joining us on the program today. Well, of course, many looking to see how across the country, as a matter of fact, the question of palliatives, what are the governors doing in their first 100 days? Have they been able to affect or impact lives positively? Well, some news came through from Adamawa not long ago about some palliatives. What can you tell us now about how the state government has impacted lives in the last 100 days?
Thank you very much, Chamberlain, and I am appreciative of this privilege. For us, we think that the re-election of Ahmadu Umaru Fintiri provides not just Adamawa indigenes, but indeed the whole country a reason to celebrate. Because we think that the 2023 elections is arguably the most topical issue since the advent of democracy in the country. Because I think it is one event where the entire democratic enterprise was probably threatened. And so the re-election and eventual swearing in of Ahmadu Umaru Fintiri provides Adamawa people and indeed all lovers of democracy to celebrate, because we saw a triumph of democracy, a triumph of the will of the people, and so on and so forth. So, but specifically on the issue of palliatives, immediately the policy pronouncement was made by the federal government that subsidy was going to be removed or has been removed. The governor immediately set up a committee under my chairmanship to design measures towards mitigating the pains that will result from that. And we indeed embarked on a research on what the situation was before the subsidy removal and what the situation is after the subsidy removal. And we looked at it in respect of cost of transportation, cost of livelihood, cost of farming inputs, and so on and so forth. And we designed very robust strategies, even before the federal government started talking about whether it is 2 billion or like they say 5 billion and all that. But the Adamawa State government has been proactive in that regard. And
all right. If I could just jump in, since you're in charge of that committee, what template are you using? First, is it published so that everybody can access it and know that really and truly this is a transparent platform, transparent list or document that the state government is relying on for this purpose?
Let let me make a correction. I am the chairman of the committee that designed what needed to be procured, but I am not the chairman or even a member of the committee that designed the template for the distribution. However, since I'm chief of staff, I'm in the know of the template. Yes, and the committee is chaired by the Secretary to the State Government with first-class traditional rulers, the DSS, the NUJ, the religious bodies, members of the House of Assembly, the local government chairman. It's all members of civil society, NEMA, ATSEMA, as the case might be. So it's well published, publicized. Everybody knows the template. Now, this was done when the governor was on leave and the acting governor was in place. So the template is there. By the way, for the allowances to civil servants, it's not about template, it's about implementation. So 10,000 naira has been added on top of the salaries of civil servants and on the allowances, I mean the pensions for those who are pensioners on the payroll of the state government. That has been implemented. We've procured buses for transportation, to ease transportation. So the template is on the grains. Again, on the fertilizer, we procured about 100 trucks of fertilizer. It has been seamlessly distributed to civil servants, to people out in the society. But the issue of template is on the grains. Now, before the governor came back, the template was that it was going to be subsidized. Now, he came a day before the grains were to be distributed at subsidized rate. But immediately he returned, he decided that instead of subsidizing it, it should be given free. Now, that affected the distribution template because of necessity now, the focus will be on the most vulnerable members of the society. Unlike in the past, those who could afford the subsidized rate will receive them. But for now, it is going to be free. So the most vulnerable are those who are now being targeted for access to those grains because we feel that that is the way to go. I mean, so that is for starters.
So what is the regularity of access to these grains? I mean, beyond that, is that something that will improve their purchasing power?
Absolutely. Adamawa is largely a civil service state. So if every civil servant has his income up, it's going to affect the purchasing power of the people in the society. If the pensioners have something that is added onto their monthly pensions, it definitely will affect that. And if you also provide fertilizer and farming inputs, the price in the market will be affected even for those who have not received it. But for those who have access to it, it will enhance their ability to go to the farms and produce more food, and it will also reduce the price in the market. The same thing with the grains. Those who receive them will have food in their stomachs. Those who are not able to get, even those who have it in the market, the prices will also go down. The cost of transportation will go down, and that will have a roller coaster effect on the cost of other things as well. So these are the templates, and the committee at the state level, it is designed in a manner that it will be replicated at the local government level, it will be replicated at the ward level, and even at the unit level.
So, Dr. Amos, if I may ask this question, staying with the palliatives matter, is there a register, like a social register you're working with, or you're just going ahead as far as you're a resident in Adamawa State, you benefit from the palliatives?
There is a social register, but we are not religiously adhering to it because we have questions on how the register was designed in the first place. So there is a social register, yes. But we also believe that working with the communities, because we have question marks about how the social register was arrived at in the first instance. But since we now have respected members, traditional rulers down to the grassroots level, we have the councillors, we have legislators, we have religious members of the religious bodies, we have robust enough to be able to identify. We think that there will be a consensus along that line.
Okay, so,
I don't know whether you get it.
Yeah, we got you there. But when you say there are questions as to how that register was put together, one would believe that the register was put together in the previous, in the last 4 years. This is a re-election, this is a new tenure. In the last 4 years, probably that's how that register was put together. So if you're saying you're questioning that, are you saying that your predecessor in your office right now, you were head of service at that time, in the last administration, you were head of service. So are you saying that your predecessor didn't do a very good job of putting it together or coordinating the activities around that?
respects to Professor Maxwell Girado, who was my immediate predecessor as Chief of Staff to the Governor of Adamawa. Very brilliant submissions. But the not just by the state government, it has contributions from the federal government and from other. But even if it is by the state government, for us to admit that we have questions about it, have questions about the way it is arrived at. And we are not discarding it entirely. We are only thinking that in this era now, we have a more reliable means of reaching.
Okay.
Which is much more credible than that.
Dr. Amos, okay, let's leave the register and go on. You purchased buses worth about R1 billion thereabout. What's the plan? How are they going to be rostered to move around? I think what the government is planning is that they're supposed to ease transportation. But the buses are not even enough, won't even be enough. So yes. How are they going to be rostered to ensure that they're effective? And sustainability.
Yes. Which are not going to be the only ones. The immediate focus of these buses is the intra-city transportation within the metropolis for civil servants. We have already identified routes that these buses will ply. The kind of buses that have about 58 people sitting and about 46 standing. 10 buses will even be too much for the metropolis. So we also believe we will deploy some of them for Man, Gire, and even beyond. But we also have plans to purchase buses for the interlocal government transportation. This we are going to buy. And perhaps I may add that we bought them from Innocent Motors, which is like buying Niger and growing Niger. So buses that we have on the carts, but this will ease transportation. Then beyond that too, as to sustainability, that is a very good question. We are looking at 3 options: whether to run them entirely by government or by the private sector concessioning them. Again, we think that is not the social implication where we want to ease the cost of transportation, because the private sector large. But the model we are now working towards is a private-public partnership where the government has brought in and invested in it, but the private sector will come in with technology. The funds will be generated and remitted, whereby the recouping its investment in terms of a percentage from what they generate. We think that is it's for the private sector running. After all, it is government that bought those buses. So we take question. And so we think that with the public-private partnership, it is going to be sustainable.
So when does the government plan to finalize on that and deploy the buses?
Sooner rather than later. After all, the buses are here. So if we don't deploy, they are here because we want to operate them. By the way, we have those teams to train them. We brought in technique on how they will be maintained. So there is an ongoing partnership. And they are already in town training and technicians on how the
I think we lost that connection with the Chief of Staff, Mr. Amos, so we'll try and get that connection back. But it's interesting, he says, that they're trying to see how they finalize on that and deploy those buses among several other measures that they are putting in place, because that is a very key component. There's been a lot of focus at the center, and now part of us asking questions of what the states are doing. So let's see if we can get him back. So we need to get some input about the 5 billion naira that the government also gave to states. Mr. Amos, are you still there? Okay, we'll try and get that because we need to find out what states, how are they deploying that, what platforms, what register, what documents are they using? Is it one that if they use today, next government comes in, it will be acceptable and not say, look, we don't know the methodology, how credible or the integrity of this document. We hear that narrative time and again. It's something that you do not want to hear again because if you spend a lot of money and resources, you deploy human capital and all of that to get those documents, I think it should be one that should be acceptable across board. So hence the need to ensure that you do all of those things well.
Mm. Yeah, it's interesting what the conversation is having, how they're going about and distributing the palliatives to ensure that it gets to the how do you say it now? I don't want to use the normal, grassroots. It gets to the grassroots. So it's really interesting, as again, the sustainability of all of that.
Let's try let's see if we, Dr. Amos, we were going to ask, we know that there was that announcement by the federal government about palliatives to state in terms of the $5 billion and the first tranche that has been distributed to the state. So what can you tell us about what Adamawa has received and how they're proceeding with it?
Like I mentioned earlier, for us, we started the issue of palliatives before the federal government started that discussion. But the Adamawa State government has accessed 2 billion naira so far, not 5 billion naira. And before they came, we had already, the buses, like you said, is about 1.06 billion naira. We had already purchased 100 trucks of fertilizers. But what we are getting from the federal government at the moment, what we have had is 50 trucks of rice and earlier 5 trucks of rice that arrived, and then another 50 trucks of rice. Then we are also getting trucks of maize. So we have not started distributing the maize because we have not gotten to that quantity yet. What we are hearing is that we will have over 100 trucks of maize from the federal government. We have gotten some quantity, but other quantities are yet to arrive. So this is the much that I can say the state government has accessed.
Okay, Dr. Amos, our colleagues in Lagos have some questions for you. Ayo Buki.
Thank you, Nelson. Let me begin. But first of all, it's commendable, Dr. Amos, that those vehicles are procured in Nigeria. So yes, we will strengthen the Naira more, and I'm hoping that other state governments will take a cue. But you know, there's something on that also that a number of state governments have done over the years, and that is to put pictures of the governor of the day on the vehicle and take around, or push to the city. Some way of campaigning, a number of people would say. And even in packaging palliatives, the bags of rice, for instance, that the governor, was giving out, a number of people would say that, okay, the picture of the governor is on it. What's the objective? Is that some kind of campaigning?
Well, we think that is petty, and it is an argument for those who are already comfortable. By the way, we have the photographs of Tinubu in all the offices of the country. Whether you voted for Tinubu or not, he is the president of Nigeria, and you must have his photograph. This is the governor of Adamawa State. Whether you voted for him or not, you have his photograph in offices, and whether it is a private office, by the way. So that it is on rice has advantages. It means that somebody who wants to go and sell it in the market will not do so, because this is already branded. So it's a way of checking the abuse of the process. And this is a governor that is loved by the people. So you see the picture of someone you love and you eat the rice from the bag. So be it. I mean, who in Adamawa State do you think his photograph will be on the rice, and then it will be a better distribution or better sale, for instance? Anybody who is hungry and is questioning the photograph on the back of the rice is not a hungry man.
Well, Dr. Amos, that's an interesting way to look at it. But still,
clearly, a hungry man will not question the photograph on the back of the rice. I don't think a hungry man will do that.
Well, let's look at other aspects of your palliative program in Adamawa State. The CNG buses, please confirm that indeed they're they're CNG powered. We know that the federal government CNG program is yet to take off. So do you have a specialized program for the buses to be CNG powered as they take off as part of your sustainability plan? Also, for the distribution of grains in the state, Adamawa is a state with a population of about 3.5 million or thereabout, or 4 million. What we see on television is, a half bag of rice or thereabout going to one individual. Is that the case also beyond what we see on television? Is that the rationing? Can it go that far through all of the residents in the state?
Well, two things. They are not CNG buses. We've not purchased them to run them on CNG, although they are convertible to CNG, but we are buying them to run them on diesel. We contemplated that issue, but we felt it's still a new terrain and we wouldn't rush into it. So they are, at the moment, diesel. On terms of the palliatives, before the governor came, the template and the committee recommended that the rice should be rebagged in 25 kilogram bags and sold at a subsidized price of 10,000 naira per bag. Bear in mind that in the market here in Adamawa State is about 48 to 50,000 naira per 50 kilogram. So 25 kg would be something in the region of 20-something thousand, 22, 23. So, but the plan by the distribution committee was that it should be subsidized at 10,000 naira for a 25 kilogram bag of rice. But the governor in his wisdom now said, no, it should be free. Now, in an attempt to get it free, it was also contemplated and desired and the decision taken that it should be rebagged in a 10 kilogram bag of rice and then distributed free of charge. Now, I consider that as a human endeavor, it's not going to be perfect. It's not a perfect world. And I think that there is no human being who will perfectly distribute this quantity of rice to the citizen. But what is clear is that we know leadership is a trust bestowed by God and the instrumentality of the people, and we take that trust sacredly. So we believe that we owe a responsibility to target the vulnerable groups. If we make mistakes, they are mistakes of the maybe head, not the heart. Our desire is that it should get to the target people. It should get to the most vulnerable in the society. The poor, the aged, women-led groups, women-led households, the disabled, and so on and so forth. We think that these are the target we will start with before perhaps the civil servants and other members of the society. But clearly, and we believe that Adamawa people trust us. And so we intend to target them and alleviate their pains. We are doing it with the whole sincerity of our heart, knowing the sacred mandate that has been bestowed on us repeatedly. Let me say that Governor Umaru Fintiri is probably the only Nigerian to have taken the oath of office for governor about 4 times. So he has come to the job more than prepared. It's not the first time, it's not the second time, it's not the third time. So we think that we have been entrusted with the sacred mandate to alleviate the pains of the people, and we intend to discharge that with all our might and focus.
Indeed, Dr. Amos, and there's the continuing part of the conversation on the register, which you say has been discarded for an alternative distribution approach to it. We understand also that the federal government at the humanitarian ministry level is also reviewing that register, but that will also expand the conversation beyond this level. We'll hope that we'll get to have you some other time for further discussions on this. Thank you very much. Back to you now, Chamberlain.
We do, thank you. So let's take a look at some messages coming through now. We've got this one from Hussein, who says, I do not see a reversal at the Supreme Court in the verdict by the Presidential Election Petition Tribunal. However, I want to see a constitutional amendment as regards winning 25% votes in the FCT and decision of election cases before president and governors are sworn in.
And then this one, Yinka Olanion says, in my opinion, INEC fulfills the promise to transmit the results electronically. The results are still there till today for everyone to see. There may have been a delay in transmission, but it was eventually transmitted. The question is, does anyone have a different figure from what is on the IREF? Inka Olanio.
That's going to be very interesting, I guess.
Indeed.
What about Law Alpha Cross? Well, he says the Presidential Tribunal judgment was overtly too legalistic, intimidating, and unnecessarily academic, laden with many jargons at the expense of facts on ground. So, oh dear. So there you go. That is the show today. We thank you all for watching. What a week it's been. We'll see you next time. I'm Chamberlain, so goodbye.
I'm Nell Taigbe. Enjoy your weekend.
And I'm Bukola Kuka. Thank you for watching. Have a blessed weekend.
And a wonderful day ahead. I'm Ayo Makinde. Bye for now.